Good afternoon, everybody, and welcome to the DC Bar Pro Bono Center and Morgan Lewis's webinar this afternoon, Open or Closed for Business, Employment Law Issues for Small Businesses and Nonprofits During the Pandemic. My name is Daryl Maxwell. I'm an Assistant Director with the DC Bar Pro Bono Center, and I will be your MC for today. Before we get started with the webinar, I wanted to first give a few thank yous. First thank you is to Lauren Paley and Christine Kulamani, members of the DC Bar Pro Bono Center staff. They have helped to put all of this together. I wanted to make sure to shout them out for all of their hard work in putting this together in a very quick sort of fashion. Thank you for that. Let me also say thank you to our volunteers from Morgan Lewis. That would be David Broderdorf, Cris Weals, Alex Reid, and Shay Familoni, who in the span of 2 weeks have been able to turn on a dime. They reached out to us because they knew that employment law was a really important and crucial issue during these particularly stressful and unsure times for business owners and for nonprofits. So I wanted to say thank you again to all of them for participating today. I just wanted to lay out a couple of ground rules before we get started. I know many of you are probably going to ask, is the webinar or is the handout and the PowerPoint that we're using going to be available? Well, if you look on your screen in the handout section, there is a PDF of the PowerPoint already there that you can review. After the webinar is over, you will be able to hear both a recording of this as well as be able to follow along with the PowerPoint. That will be available on our resource site, lawhelp.org/DC/CED. Additionally, if you have any questions, and I'm sure there will be many, there is a chat function in the box where you can also see the PDF where you'll be able to ask questions. I will be reviewing those questions and then sharing them with our presenters. We will try to hold as many of them till the end, but again, they may at some point ask for questions. As we've all been sort of witnessing and experiencing together, these are extremely uncertain times, and we are all fairly unclear as to whether or not we were able to keep staff at the levels that we would have kept up a month ago, whether or not we might have to think about furloughs, possibly layoffs, possibly trying to apply for monies that could help us to stem this tide. And this webinar today is going to help both with what both the law that's currently in place and any new laws that will affect how we operate now and moving on into the summer and into the fall. Our friends from Morgan Lewis will help walk us through that. Again, if you have any questions, make sure to place them in the chat function. And right now, I'm going to turn it over to my friend David Broderdorf to get us started. Thank you, David, very much.
Thanks, Daryl. And I'm here with my colleagues from the Morgan Lewis DC office, Cris, Shay, and Alex, and we're going to walk through today an agenda that is laid out on the next slide, and we're going to try to pull that up here. Daryl, could you move that slide for us?
Sure.
And there it is. So we wanted to present to you today 5 main topics. These are topics that we think are raising frequent questions and issues. They're topics that in some cases change literally daily. And we're going to do our best to move through these topics in the hour that we have, provide you information that we hope will be useful. But again, a lot of these things are changing almost daily, and it's going to be important going forward for all of us who have an interest in the employment law space and human resources and business operations to just remain vigilant and on top of all these issues. And so diving into the first category here, which is temporary furloughs versus indefinite layoffs and related issues. Cris and I will be tackling that before we move into some of the other items on the agenda. Great. So the first section today is called temporary furloughs versus indefinite layoffs and related issues. So as slide 4 shows you, these are the historical ways that businesses and employers have adjusted staffing levels in response to changing market conditions or other issues, and that's included in some cases all or select one of the items on this slide: reducing hours in the top left, changing hours, temporary reductions, indefinite reductions, terminations, and then changes in the outside contractor relationships. What's really significant about the current situation is the interest level in the temporary reduction category as well as indefinite reduction versus terminations. That's really become a critical question or a critical issue facing employers that historically it's been less important. And the reason is we all hope and we all plan for this to be a temporary period. And what we're experiencing now, we're hoping, is not some sort of indefinite or long-term impact on the staffing demands. But that said, because of this unique situation with the pandemic, it's led to critical questions about what is a temporary reduction and what is an indefinite reduction and what is a termination. What do these distinctions mean, and how am I going about complying with those distinctions in terminology, because they could have legal implications as well. So if we could move to slide 5. Daryl, could you take us to slide 5, please? Great. So focusing on the temporary furloughs with a definite return date. These are situations where the employees effectively are remaining employed, but they are going without pay. So there's no hours of work, there's no pay, but there's still that linkage to the employer and some sort of ongoing employment relationship despite the current situation. And as part of the temporary furlough structure, the general approach is to provide a definitive or a definite return to work date that's probably within the next 6 months. So you could have a 2-week furlough, a 2-month furlough, but in general, it's going to be communicating to that employee, look, we don't have work for you now, but we expect as of June 1 or July 1 to have you back actively working. One of the things that we've seen out there is an interest in potential continuation of company paid benefits or other programs for individuals who are furloughed. And things can change. So we understand that at one point things can be a furlough and you may expect someone to come back on June 1. Furloughs could possibly be extended, and even as necessary, terms and conditions of employment can be altered after the furlough ends. And the temporary furlough is really distinct from what we're calling here on slide 5, the indefinite furlough or layoff, where employees do not work and are not paid, but the period of the furlough is unclear and not defined. So you're unable objectively, based upon the information you have, to give the individual a clear and defined return to work date. And for the most part, indefinite furloughs with no pay are considered analogous to an employment separation or termination event. And so, Daryl, if we can go to slide 6, please. So talking about temporary furloughs, is there a requirement or not to essentially pay out wages and accrued vacation and PTO? So that's going to vary based upon state and employer policy. Obviously, if somebody has worked certain hours or worked certain weeks, then paying out their final wages is going to be legally required. But because, and as you see here with respect to DC and Maryland and Virginia, because under a temporary furlough situation, the employment relationship is not severed and there is that definitive or expected return to work date, that you may not have to pay out the accrued vacation or paid time off. So there's a distinction where wages, meaning salary or hours of work earned, is different than paying out, for example, a vacation bank or a PTO bank. And again, one of the benefits of a temporary furlough is you're maintaining that relationship, so the obligation to sort of pay out all those accounts may not be there. That said, an individual employer can decide to pay out certain benefits per policy or practice in order to help people during this difficult time. So now I'm going to shift over into indefinite furloughs and have Cris tell us more about how they're akin to a termination event.
Great, thanks, David. Just advancing to the next slide. I think we jumped 2 there. Can you go back 1? So David already pointed out the distinction between a temporary furlough and an indefinite layoff or termination. As he said, the furlough implies some sort of temporary cessation of work with an expectation of return within some period of time, less than 6 months. But a layoff or termination really severs the employment relationship and triggers what's shown on this slide, which is requirements for final pay and for payout of leave. So the timing of the final pay depends on what jurisdiction you're in. DC is really the anomaly here. Pay must be, final wages have to be paid out the next business day. The other jurisdictions allow final pay to be on the next pay date. With regard to PTO, largely depends upon what your policy says. In DC and Maryland, if your PTO or vacation policy says that the employee forfeits that, then that's permissible. But in the absence of a statement like that, the requirement is to pay out any banked PTO. Clicking to the next slide. And I got this. I seem to be control now. This slide is just kind of a quick reference guide to thinking through the issues with regard to furloughs, layoffs, or termination, kind of going through the process. Step 3 is particularly important. You want to make sure that your payroll or your HRIS system correctly identifies the action that's being taken and that it's consistent with what's being told to the employee. So if the employee has been told that they are being furloughed, you want to make sure that is with some expectation of return to work, that employee record should reflect that. Ensuring consistency in your records is always important, but especially in this current environment, you want to make sure that you're correctly tracking the actions that are being taken and communicating it to the employee. On the next slide, this of course raises the question about what leave rights may exist. So Shay's going to talk in a minute in a few minutes about the new federal paid leave laws. So one question that comes up is, how do these work with furloughs and layoffs? So the short answer is that if an employee is furloughed, laid off, or terminated, they're not entitled to leave under these new federal leave laws. Likewise, if the employer closes, even for a short period of time, and no work is available, the employee cannot take paid sick leave or expanded FMLA leave under the new federal laws. And these are just references to 2 Department of Labor guidances that make these points clear. Waiting for the screen to load. Can we move it to the next one? One other issue that was discussed briefly by David, and that is, to the extent that you have either relationships with third-party contractors or vendors who may be working on site, or individuals that you have hired in independent contractor relationships. Just remember that independent contractors aren't employees, so you don't want to be using terms like furlough or layoff with regard to contractors. What you really need to do is look at the agreement, whether that's an individual contractor agreement or a vendor contract, to see what the termination provisions are. There may be outs within the agreement that will allow you to invoke, for instance, a force majeure clause to end the relationship. So with that, I am going to pass the baton to Alex.
Great, thank you very much. Hi, everybody. I'm Alex Reid, and I'm a tax lawyer focused on nonprofit organizations. I'm going to talk about something that's a bit outside my area, but something that is of extreme importance to everyone right now, especially nonprofits and small businesses in general, which is the Paycheck Protection Program and federal stimulus. So for those of you following the news, we had a couple weeks back the CARES Act, which created this new program to try to preserve employment as best it can by making forgivable loans through this Paycheck Protection Program. It also has a new facility for the economic injury disaster loans. And then we'll talk about two additional tax elements, the employee retention payroll tax credit and payroll tax deferral. The Senate right now, so headline, the Paycheck Protection Program has been drained. New headline, the Paycheck Protection Program is about to be refilled. So that's a sign of its success, arguably. It's about to get an infusion of $310 billion additional dollars. And we're also going to see a $60 billion additional replenishment to the economic injury disaster loan. So that's passed the Senate, but hasn't passed the House yet. So back to the details. So the headline is, should I apply? Yes, give it a shot, and see what your loan officer is willing to provide, because it can be very advantageous. Okay, starting with the bullets on the left here. What the program offers is partially or fully forgivable loans. Of up to $10 million. I haven't seen a $10 million loan, but a number of our clients have gotten loans in the amount of $700,000, $1 million, $2 million. So it's real money, and it can happen for you too. It focuses on payroll, mortgage, interest, rent, and utilities costs. So you're looking at overhead and the types of budgetary items that you might have planned for at the beginning of the year before taking COVID into account, and then suddenly find that your budget isn't working out quite as well as you expected, and instead of laying off employees, the idea is you can get this loan to stop as a stopgap. Note that if you qualify for loan forgiveness under the PPP, you're not eligible for the other programs. So there's no double, triple, or quadruple dipping on these different measures. Okay, so the key eligibility criteria are: you have to have 500 or fewer employees. You have to make a good faith certification that the loan is necessary to support the ongoing operations due to the uncertainty of current economic conditions. That's a fairly easy criterion to meet, given the uncertainty we all face right now. You have to represent that you will use the funds to retain workers and maintain payroll, or make mortgage, lease, and utility payments. And you have to represent that you're not applying for duplicative additional funding. Maximum amount is 10 million, the lesser of 10 million, or 2.5 times the, sorry, it looks like auto advanced there. If we could go back to slide 13. There's 15, we want to go to 13, there we go. The lesser of 10 million or 2.5 times the organization's average monthly payroll for the past 12 months, excluding compensation over $100,000. So that's really the key for figuring out the amount of loan you're eligible for. It's just math. It's just arithmetic even. So it's it's something that anyone with a calculator can do, and it's a very simple application there. So the main point really is this this forgiven point at the end. So if you maintain your payroll, you are able to have the loan forgiven. So that makes it really a grant rather than a loan. The interest rate is going to be around 1%, and you don't have to pay it back if you manage to keep the employees for that period. Okay, let's move on to slide 14. I'll be a little faster on these others because they will. The PPP is really the main one. But here's the economic injury disaster loan, or EIDL. These are loans of up to $2 million for private, and they're available for private nonprofit organizations that have suffered a substantial economic injury. They are available to any non-governmental entity or entity that currently has a determination letter that is described in 501c. So that includes C3s and other types of 501s, whereas the PPP is only for C3s and C19. So if you're a labor union, business league, or social welfare organization, a C4, 5, or 6, or a social club, C7, you're not eligible under the PPP. Organizations are not required to apply for recognition for exemption, might not have a determination letter, but you would still be able to meet the requirements. All right, let's look on the next slide. Okay, this is the employee retention payroll tax credit. And remember, these are in the alternative rather than supplementary to each other. So you can have up to $5,000 in refundable tax credits per employee as relief from the employment tax burden. So nonprofits are exempt from income tax, but they are not exempt from payroll Social Security taxes. So you do pay the employer's share of employment taxes, and you can get a refundable credit of up to $5,000 per employee. So that can be real money. You have to first use the credit. It gets reduced by other qualified sick or family medical leave paid under the Family First Coronavirus Response Act. So that was a prior act. We're actually up to the fourth bill now that Congress has enacted. An exempt organization is an eligible employer if its operations are fully or partially shut down due to COVID-19, or it experienced more than a 50% decline in gross receipts as compared to the corresponding calendar quarter in 2019. It applies to 50% of the qualified wages up to $10,000 paid to each employee. Now, the key here is it's between March 13th and December 31st of 2020. So you consider that in making your determinations on whether to terminate an employee or keep them. Okay, payroll tax deferral. This will be, I think, this is my last slide before kicking it back to our friends here. Payroll tax deferral is a special nonprofit employer program. Nonprofit employers' Social Security tax payments otherwise due between enactment of the CARES Act on March 27th and the date of December 31st, 2020, you can delay your Social Security tax payments. The deadline for paying the first half of the deferred taxes is December 31st, 2021, which is a long time from now. The deadline for paying the remaining 50% is the following year, December 31st, 2022. The delay provisions are available regardless of the relief. Last point here is that Montgomery County Maryland has an emergency relief for local employers. On March 31st, the Montgomery County Council enacted a public health emergency grant program that provides up to $75,000 grant for eligible small businesses or nonprofits that have been impacted. So that's a helpful thing for the local nonprofits in Montgomery County. And with that, I will turn it over to the group.
Hello, everyone. My name is Shay Familoni. I work in the Labor and Employment Group at Morgan Lewis. So today I will discuss federal and local paid leave programs along with Cris Weals, who will discuss the local piece of these laws. Okay. All right. Sorry, let me just go back. Okay, so there are two laws that have been enacted due to the COVID-19 situation that provide leave benefits to employees. These two new laws were enacted as a result of the Families First Coronavirus Response Act, the FFCRA, which some of you might be aware of. So these laws provide paid sick leave as well as expanded family and medical leave provisions, which apply to certain public employers as well as private employers with fewer than 500 employees. So what this does is, with the two new laws, the Family and Medical Leave Expansion Act will now apply to employers who may have not otherwise been applicable or had to provide the FMLA, which has been in existence prior to the enactment of this expanded Family and Medical Leave Expansion Act. Both laws became effective on April 1st, 2020, and they will go through December 31st, 2020. I will discuss what these laws require, but do note that although it does require a lot from employers who maybe did not provide these benefits before, there is the federal government does allow a tax credit for these costs. I will also discuss how that works. So the two laws, the Emergency Paid Sick Leave Act provides 10 paid sick days up to 80 hours for specific needs arising from the COVID-19 emergency. And the Emergency Family and Medical Leave Expansion Act provides 12 job protected weeks, of which 10 of them must be paid for one limited COVID-19 reason. So the Paid Sick Leave Act is actually more expansive. It is only 10 days versus, the 12 weeks for the Family Medical and Leave Act, but it's limited. The Family and Medical Leave Act is limited to particular COVID reasons, whereas the Paid Sick Leave Act is broader in what it covers. And I will go into specifically what the COVID-19 specific reasons are. Okay, so the paid sick leave mandate, which again provides up to 2 weeks, applies to full-time and part-time employees regardless of when they started working, which is a big distinction. So if they started working a day before, they are eligible for this leave. It requires paying 10 days of paid sick leave up to the cap of 80 hours. Part-time employees are also eligible, but they receive prorated hours based on the average hours worked over a 2-week period. The amount that can be received through the paid sick leave mandate does differ depending on whether the sick leave is being used for the employee's own needs or if it's being used to care for someone else. So if it's been used for the employee's own needs, it will be paid, those 10 days will be paid at the regular wage, the full regular wage of that employee. However, if it's being used to care for someone else, it will be paid at 2/3 of the employee's regular wage up to the cap. So the cap provided is $511 per day for the employee's own needs. So that's being paid at the full regular wage, or $200 per day if it's for the employee's caregiving needs, so taking care of someone else. Okay, so what are the reasons for taking paid leave due to COVID? So this new law, the FFCRA, which is in effect till December 31st, qualifies employees for leave if they're unable to work and need to take leave because, for example, there are 6 reasons. So the first one is that the individual is subject to federal, state, or local quarantine or isolation related to COVID-19. The individual has been advised by a healthcare provider to self-quarantine due to COVID-19, or the individual is experiencing symptoms and is seeking a medical diagnosis. So if the person is looking to get tested for COVID, they are also entitled to the leave laws. Okay. All right, so the 4th reason is related to caring for someone else. So if, for example, the person has a child that was subject to quarantine or isolation, they're also eligible for the paid leave, or if the individual has been advised by a healthcare provider to self-quarantine as well. It's also available for caring for a child whose school or workplace has been closed or the child care provider is not available due to COVID-19 reasons, or if they're experiencing any other substantially similar conditions that has been specified by one of our authorities, such as the Secretary of Health. Okay, so moving on to the next slide. Okay, so the expanded FMLA leave. So this is the narrower piece of the law. The paid sick leave, as I discussed earlier, can be used for a variety of reasons, those 6 reasons that I mentioned earlier, but it is limited to 10 days. However, the expanded FMLA leave expands the FMLA to employers who have less than 50 employees, which was not the case before. So, but there are some differences in the eligibility for the expanded FMLA leave. This leave is available to full-time and part-time employees who have worked for the employer for 30 days. So unlike the paid sick leave, which could have started if right when the employee started, like a day after, the employee here has to have been employed for 30 days to be eligible for the expanded FMLA leave. It's also, this is very key, it's available for only one of the COVID-19 reasons. The paid sick leave was, it's applicable for 6 different reasons. The expanded FMLA leave is only applicable for one reason. And the reason is that an employee cannot work or telework in order to care for a child if the child's school or care location has been closed or if the child care provider is not available because of COVID-19. There is a small exception for businesses that have fewer than 50 employees. And the exemption is only related to the expanded FMLA and the requirement to provide leave for school closings or childcare unavailability. The exemption can apply if providing the leave requirement would jeopardize the viability of the business as an ongoing concern. We have seen guidance that there is no formal way to apply for this exemption. You don't send the documents anywhere. You don't send it to the DOL or the IRS. You just keep the records for yourself in case of an audit or record keeping. And there are 3 reasons, which I won't go into detail about, for which you can be eligible for the exemption. And it's typically related to financial issues, unavailability of employees, or it would affect the business in a detrimental way. So in order to seek that exemption, it's important to make sure that you fall into one of those 3 reasons, and obviously having employees, having less than 50 employees. Another difference with the expanded FMLA is that the payment is 2/3 of the employee's wage, not the full regular wage. And it is capped at $200 per day and $10,000 in the aggregate because it can be paid for the 10 weeks that the expanded FMLA is available for. I will note that although the law it provides for 12 weeks, 10 of which must be paid, it is possible for an employee to use the first 2 weeks that are unpaid, to use the paid sick leave law to have those paid. And then, use the expanded FMLA to cover the rest of those. Okay. The law is not explicit on how it interacts with 12 weeks of job protected unpaid FMLA leave, which some of you might be required to provide if you have employees, if you have 50 or more employees. But we did get some guidance recently that it does run concurrently. So if an employee has already used 12 weeks of job protected unpaid or paid FMLA leave, if you provide paid FMLA leave for your employees, they could possibly have run out of the opportunity to use the expanded FMLA. If they have some FMLA left over and they haven't run out, they would be able to use this expanded FMLA to cover the remaining weeks. And I already discussed the fact that you can use the first 2 weeks, which are unpaid. You can use the Paid Sick Leave Act to compensate for those first 2 weeks. So how do you get your costs from providing these benefits, right? They do seem like they are substantial, but the government will allow employers to receive a tax credit in the amount equivalent to the maximum leave amount that you as an employer have paid out. Nonprofits also get the same tax credit against their payroll taxes. Similar to the exemption, employers should retain information of how much they've paid out in order to claim the benefits. Typically, employers will retain the taxes that they would have paid for the employee and the employer's share of Social Security and Medicare taxes, as well as their withholdings for federal income taxes. But from a documentation perspective, employers should keep just information of the employee's request, how much was paid out, just from an auditing perspective. All right, so if there is a situation in which an employer has paid out more money than they would have withheld, you can receive an expedited advance from the IRS. And you would need to follow the instructions provided by the IRS in order to seek the expedited advance, and that can be found on the IRS's webpage. You can begin seeking it as of this month. They started that process in April of 2020. So if that's a situation that you're facing, you can seek an expedited advance if the amount that you would have withheld is not enough or sufficient to cover it. Regarding notice, so employers must post a notice about the requirements of the law. There is a model notice that you can download from the DOL's website, the Department of Labor. This is a visual of what the notice looks like. There's also a non-retaliation provision, so you cannot discriminate against an employee for using any of the leave requirements, and you can't retaliate against employees for taking the FMLA leave. And now I will pass this over to Cris, who will discuss some of our local laws and how they interact.
Thanks, Shay. Just to make things even more confusing, the District of Columbia has layered some additional leave entitlements on top of the federal law. I'm just going to briefly touch on two of them. The first one is what I'll call the Declaration of Emergency Paid Leave. This was passed just a few weeks ago, I think April 10th. We really don't have any guidance from the DC Department of Employment Services as to how this is going to work exactly. So we're really just going off of the law for right now. The good news for small employers is that it only applies if you have between 50 and 499 employees. So if you're under that, you can just check this one off. It grants the same leave or grants leave for the same reasons as the FFCRA. That's those 6 reasons Shay went over. Just some important differences though. The leave is paid at the normal rate, and there is no cap. There's no tax credit. And everyone's reading of the law so far is that this leave, this paid leave entitlement is on top of or in addition to the emergency paid leave that's provided under the federal law. So it's an additional entitlement of essentially the same amount. I believe we jumped ahead of a slide somehow. I apologize for that. Can someone click back one just so we can have that one up? Thank you. All right, so this was the law I was just describing, so I just want to make sure I was looking at the different screen. But as I said on this one bullet near the bottom, it is in addition to the existing leave entitlements under the federal law. But if you're under 50 employees, you don't have to worry about this. The second one, which should be coming up now. And of course, we went too far. There's a slight delay in when we get the slides, which is why we're having a little bit of an issue here. The second thing DC did was it expanded the Family and Medical Leave Act under DC law. This is unpaid, not paid. It applies to all employers regardless of size. And unlike the DC FMLA, there is no 12-month 1,000-hour requirement, so employees are eligible immediately. It's not crystal clear what all the qualifying reasons are for this, but I think you can assume that in the District of Columbia, as long as the mayor's public health emergency is in place, which is through mid-May at this point, that an employee is going to be able to access this unpaid leave. And finally, I'm going to skip over this slide. Maryland has some, basically hasn't done anything with its laws, but their existing laws may provide leave for COVID-19 related reasons. And now it's to David. Thank you.
Thanks, Chris. So we would like to spend a little bit of time on unemployment compensation. Perhaps no area connected to the employment relationship has seen such a radical change in the structure of the benefits as well as the number of people. You may have seen on TV or the internet a graph where you see number of unemployment claims down at the bottom of the chart in the hundreds of thousands. And then all of a sudden, as of the end of March, you'll see the weekly claims spike 10 to 20 times what they historically are, all the way up to 3, 4, 5, 6 million per week. So there's been a dramatic spike in unemployment. It has frankly overwhelmed the unemployment offices, which are managed at the state level. And what further has added to the issues beyond just the number of people applying for unemployment is the fact that the federal government, as part of the CARES Act, which we talked about earlier in the presentation, included a specific expansion of unemployment compensation on 3 different levels. And so on slide 33, we describe those 3 buckets. One is called the federal pandemic unemployment compensation, which you may have read about or heard about, which is the extra $600 per week on top of whatever the ordinary state benefit would be, which is funded by the federal government through the end of July. And then the second category is the pandemic emergency unemployment benefits. That really extends the traditional deadline of unemployment benefits another 13 weeks. So basically kicks it into later into 2020 to the extent that there is still unemployment linked back to this incident. And then finally, perhaps the most I would say category that simply hasn't existed before is the pandemic unemployment assistance, which is the piece of this puzzle that links to the independent contractors and self-employed individuals, where historically those individuals were not eligible, but that is the provision that does make them eligible, and it's created additional issues for the state unemployment offices in trying to manage through that. And as some of you may know or have personally experienced, that has led to delays in monies being eligible. But ultimately, the goal is to ensure that those individuals too are able to tap into the program. And since it really is the biggest difference, we wanted to spend just a little bit of time with you on this issue, which is called the PUA piece of this, the one that applies to independent contractors and self-employed individuals. So again, it creates an eligibility and application process for those who may lack a sufficient work history or come from an independent contractor or self-employed background. It also may apply to individuals who have exhausted rights and benefits under other provisions, and that these benefits are available up to 39 weeks, similar to the other unemployment benefits. And we wanted you to walk away understanding, well, what are the eligibility criteria for this new system? I will tell you that individual states and locations may have different approaches in how this is ultimately going to work out. Again, they may have different timelines for how this is all going to work out, but there are approximately 11 categories that create eligibility for those who self-certify and report that they are that they have work access issues due to the following reasons, and with the first being diagnosed with COVID-19 or have symptoms of COVID-19 for which they are seeking a diagnosis. Number two is a member of their household has been diagnosed with COVID-19. Number three is they are providing care for a family member or household member who has been diagnosed with COVID-19. Number four is a child or other person in the household for which they have primary caregiving responsibility is unable to attend school or another facility that is closed as a direct result of the COVID-19 public health emergency, and that school or facility care availability is required for the individual to work. It's likely that that category 4 is going to be one that is oft-cited by individuals who apply. Number 5 is they're unable to reach their place of employment because of a quarantine imposed as a direct result of the COVID-19 emergency. Number 6 is they cannot reach their place of employment because a healthcare provider has told them to self-quarantine due to COVID-19 concerns. And by the way, we provide examples underneath where the DOL at the federal level has provided some additional guidance about who may or may not qualify. So if you have questions, feel free to take a look at those examples and then follow up with the actual DOL materials or connect with someone who can help you with that, because there will be additional guidance and sort of qualification for some of these factors. Number 7 is they were scheduled to start employment and do not have a job or unable to reach a job as a direct result of COVID-19 public health emergency restrictions. And number 8 is they have become the breadwinner or major support for a household because the head of the household has died as a direct result of COVID-19. I hope that is one that is less cited, included by everyone on this call. Number 9 is they had to quit their jobs as a direct result of COVID-19. Number 10 is their place of employment is closed as a direct result of COVID-19 public health emergency. That one may be one of the more cited ones as well. And then there's sort of a catch-all factor 11, which is subject to guidance from the Secretary of Labor at the federal level, who will be, again, sort of managing this from a federal level, but ultimately the individual states will be working with the federal government, given that the monies are coming from the federal government and the eligibility and the construct for this is part of a federal program that will be managed through the individual state offices that have existed before this. And to round out our unemployment discussion, we wanted to mention a program that really doesn't often get invoked, and I'm not sure how the DC government has been approaching these issues lately, but there is a concept called work or job sharing, which can involve a situation where an employer decides to take a portion of the impacted group and say, rather than lay off or perhaps furlough or even terminate a certain percentage, we'd like to combine jobs to, in effect, save jobs. And by combining those jobs, hours are reduced, pay may be reduced, but the DC government, through the unemployment benefit system, will approve of that shared work program, and essentially through the unemployment system provide the additional funds to the business, to the individual employees that would offset the compensation loss during the period of the shared work. So we have a link there for an application. So if you've already pursued this, then I would say keep doing so if you can. And if it's something that you want to take a look at, start with the application and other available resources with the DC government, and see if that's something that can help your business or organization. So that takes us through the unemployment compensation issues, and we're now going to the final section, which is called reopening. You may already be open, you may hopefully be reopening, but wherever you're at from a business or organization perspective, Cris is going to walk us through some of the key considerations that we're seeing pop up out there, and provide some sort of takeaway advice and topics for you to think about.
Thanks, David. So at a very high level, the exact return to work or return to the office plans are going to vary by jurisdiction, and it's really going to depend upon what the governor or the mayor or the public health authorities are saying. So it's hard to provide any detailed guidance without knowing what these plans are going to look like. And just for our audience, I would suggest, if you'd like, if you want to go to the Morgan Lewis website, we do have a law flash that came out recently called Reopening the Workplace. Just go to our main website and go to Our Thinking, and then it's under Publications. So I think we have to assume that some or all of the following are going to happen. The first is flexible scheduling or staffing, having rotating shifts, red and blue teams, for instance, and allowing people to continue to work from home if they can. Personal protective equipment is going to be required in some and perhaps all workplaces, depending on what the plans look like, what is required by the jurisdiction's laws, and what the particular employer is going to be doing. Cleaning and disinfecting will become much more important. There will likely be social distancing plans to reduce the density within the offices and interaction with other employees, like spacing desks out, closing common areas, conference rooms, cafeterias, things like that. Another thing clearly is going to be a lot more signage, as we now see on the sidewalks as we go to pick up our coffee, that we have to stand in a certain place or can only go one direction in the grocery store. There's going to be a lot more signage around about what you're going to do and can't do. Managers are obviously going to need to be trained on compliance and oversight. And the final thing is testing. We could spend the whole hour on testing. It's been in the news a lot. I think we're going to see employers requiring some sort of testing as a condition for returning to employment. The EEOC has not specifically said that COVID-19 testing is a medical exam under the ADA, but based upon their guidance on taking employee temperatures, we think that they're going to permit employers to require testing as a condition to return to work. And employees who refuse to be tested will likely be, you'll be able to deny them access to the work site. Of course, if you decide that you're going to put in some sort of testing, you're going to have to decide what type of test, who's going to do it, who's going to be tested, how often, et cetera. So these are all issues I think we're going to be learning more and more about. But I do recommend you take a look at the Morgan Lewis website and that guide there. And this slide here just has some more details about some of the social distancing plans. And with that, it's a wrap.
Well, Cris, thanks so much. Also to you, David, Shay, and Alex. I know we have quite a few questions that we are going to need to get to. So to get us started, I'm going to ask my colleague Christine Kulamani to jump on and ask a few questions that I know a couple of the attendees are interested in sort of getting some more information about. So Christine, if you could.
Thank you. So to get started with some of these questions, something that a lot of folks are wondering is if they're based in DC, but right now their employees are working from home in Maryland or Virginia, which employment laws apply to them at this time because the employees aren't in their normal workplace? Is it Maryland, Virginia, DC?
So this is Cris Weals. The DC laws, as I mentioned, they just dropped these on the business community. There's no guidance, there's no regulations, there's nothing on any of the websites about these laws. I think it's safe to assume that the person's place of employment prior to the pandemic is going to be controlling for purposes of compliance with these laws. So that is, if the individual's normal place of employment was in the District of Columbia, then that person would be subject to the DC laws as you normally would, even though they may be working from home in Maryland or Virginia. That's not crystal clear, but I think that's a reasonable assumption to make based upon the laws at this point.
Okay, that makes sense.
Right, and if I could just add one thing, I think I agree with Cris. But coming out of this, if an employer ends up, from a telework perspective, really finding that the telework situation is working, and somebody who historically came in from Virginia to DC or vice versa ends up with a more of a permanent telework situation coming out of this in the next several months, that may be a time to essentially say that the situs of their work has changed by virtue of this more permanent structure. But at least, as Cris said, if we're in this period now, which everybody is trying to react and deal with it, that from a legal perspective, the historical place of employment should remain the applicable jurisdiction, even if somebody is performing work temporarily from home or somewhere else.
Okay. Are there any steps for folks that have been able to keep staff on until now, but may have to let employees go in the future? Tips for what they should and shouldn't do, and maybe what generally that process should look like?
This is David. I'm happy to start with that. I think it's a great question. I think there's been a lot of wait and see and trying to adjust and react to all the situation, but there's a number of employers that sort of wait and see has that period has sort of run out, and this has gone on longer than I think most people would have hoped 6 or 7 weeks ago when all this started to break. So I think it's just a question of looking at where are the staffing needs at right now, where are they going to be, where if you do reasonably hope for an uptick later on, that you look at more of that for that temporary furlough construct and continuing the active employment relationship, which we discussed, versus doing an indefinite layoff or some sort of separation. And in conjunction, considering options of bridging that time period, if you do envision sort of improved circumstances within the next several months, of looking at the different federal loan programs, PPE or the other ones, to try to generate some additional funds to keep people at least partially or fully on the payroll during that time. But otherwise, to let people know that there is the unemployment backstop if individuals are taken off the employment rolls, where there's a benefit, historical level of a certain benefit plus the $600 from the federal government. And in fact, there's been some debate in Washington linked back to when they passed the law several weeks ago that there's actually, for some individuals who make less than the new unemployment benefit level with the 600, that there's actually an incentive to maybe want to be on unemployment versus keep staying on the employment rolls at a reduced level of pay or even full pay, because the unemployment program could actually pay people more. So there will be a pool of people who potentially would be quote unquote better off on unemployment. But I think ultimately from the employer's perspective, they should be looking at how do I, if possible, maintain this relationship for what could be better days down the road, and look to the existing federal funds and perhaps even local funds and programs to try to bridge that gap, and to communicate as often as possible with individuals so that they know what's going on and that you're doing the best to help them out and understand what options there are and that you're making the right ones.
Okay.
Any other thoughts from the team?
No, I thought that was a great answer, David.
So one more question, moving down the line a little. Employees have to be let go, and now they are starting to apply for unemployment insurance benefits. How should employers handle receiving notices? And what do they have any obligations to respond or correct information that's provided on there if it's incorrect?
Yeah.
So my general advice on unemployment compensation is to have a robust response system in place. And so for some employers, historically, that's been to work with third-party insurers or unemployment compensation administrators that help with that. But if you don't, and if you have that system, then I would say continue it and make sure it's working for you. If you don't have that system and it's handled sort of more at an individual level or a smaller level, I would recommend looking at the paperwork and responding with information. The government is just being inundated right now. It's like a fire hose of not only applications for all these different programs, but individuals with questions and different issues. And so you may not get the most timely response, or the information you provide may not quickly be incorporated into an application or the file. But I would, if feasible, make sure that information that needs to be corrected is corrected, especially if there's going to be a negative impact on the employer or the organization by virtue of not correcting the record, if you will. So, for example, if somebody says that they're now unemployed, but they're essentially working the same hours, or are providing false information in order to try to get an additional benefit, that is probably Exhibit A for one that you would want to quickly follow up and say, no, our information is this person is still engaged, they're still working X hours, and this information is not correct.
Yeah, this is Cris. I just interject that the reason for separation is often one that gets employers' attention when that unemployment insurance form comes. Just make sure that what the employee has said about the reason for their departure is consistent with your understanding. So if they said that they were laid off, but in fact they were termed for cause, you want to make sure that's corrected, because that's going to have an impact on their eligibility.
All right. Now, Daryl, do you have some more questions from attendees?
I do, and we probably can't get there. I have a bunch, and we can't get to all of them because we're a little bit over time. But there was one question. So I'll throw out two questions, or one of them is more of a comment than a question. But the first is in the PowerPoint, it states that you can't. I think this was Alex that was talking about this, that you can't take advantage of both the PPP and EIDL at the same time. And one of the attendees had mentioned that the attendee had heard from different guidance, or the exact opposite guidance, from the SBA. I will say that I was on a similar call and heard the same guidance, that you could take advantage of both. So I wanted to share that. I'm happy to ask the SBA about that when I'm on a call with them again. But that's just the guidance that I had heard. I was gonna say, Alex, if you wanted to. Oh, I see Alex jumping on now.
Oh yeah, hi. Yeah, my understanding is that they are separate programs that don't. I mean, there are particular rules that you have to follow, and so I wouldn't say that it's quite as neat as that you can just take both, but they are separate programs with separate eligibility requirements, and there are some interactions between the two. So I think that's probably at a high level sufficient for this purpose.
Okay. And then one last question. Does there need to be an agreement with an employee to pay out their accrued paid sick leave, or can an employer pay out accrued paid sick leave or can they just pay it out to the employee? Does there need to be something in writing or something to that effect?
This is Cris Weals. No, I didn't mean to give the impression that there had to be something in writing. The employer is always free to pay out PTO. The problems come when you don't pay it out. And if you don't pay it out, you need to have a policy or something in writing that clearly states that PTO is forfeited.
Okay. Thanks, Cris. I know quite a few of you have some additional questions. We will do our best to try to filter through them and answer them as best we can after the webinar if we haven't already answered them. I just want to say thank you all for attending and for your time, your attentiveness, your interest. I know this is a topic that we will certainly have questions about again. I want to say thank you, of course, to David, to Cris, to Alex, and to Shay for giving so much of your time and so much of your expertise to the small business and nonprofit community in the District of Columbia and in our surrounding jurisdictions in Maryland, Virginia, as well as whoever else has been lucky enough to join us today. Like I said before, we will post this on our resource site, www.lawhelp.org/DC/CED. And for those, Cris had also mentioned the resource, the Law Flash resource. I just sent a note to everybody on that was on at the time, and I will also make sure that in our survey we make sure to share that with folks as well. I've already gotten a good note about how thankful somebody was for this information while we were on here. So again, my thanks to our friends from Morgan Lewis, my thanks to Christine and to Lauren for all of your help putting this together. And again, if you guys have additional questions, you can always reach us for questions. We are doing small business clinics on an every other week basis, and we are certainly open to answer as many questions as we can from you. You can schedule appointments through our resource site, like I mentioned before, lawhelp.org/DC/CED. Thanks again for all of your attentiveness. Have a wonderful day. Take care.